Well, good afternoon. We'll go ahead and get started today. Thank you all so much for hanging around to the last session. Today we're going to be talking about defending your district and defending yourself, what you need to know about discrimination, free speech, and Title IX best practices. To tell you a little bit about myself, I'm an Ohio licensed attorney. I serve on the board for the National School Board Leadership Council. I'm also an ADF allied attorney with Alliance Defending Freedom, as well as a Fair Legal Network attorney. That's the Foundation Against Intolerance and Racism. I serve on the board of contributors for the Cincinnati Inquirer, and I've had a lot of experience as a registered lobbyist and legal counsel for conservative nonprofit organizations. My husband and I are law school sweethearts, and we operate, it was easy to find each other as two constitutional originalists.
There were two going there, probably.
Not much competition.
And we operate my own legal practice out of Cincinnati, which services clients across the state in both public relations and in legal representation. All that really means is that we just so happen to be bilingual in English and legalese, which is something, I know, it's something that all attorneys should be able to do, but it's not as common as you would think. We have a focus on education and employment law, as well as nonprofit organizations, and we're dedicated full-time to protecting, defending, and pursuing the constitutional rights of students, teachers, and employees. We are believers in Christ. We do believe that this is a calling, particularly when you're dealing with clients that have such important causes that are related to their rights in this space. We went into private practice because we truly have zero interest in ever running for office. We are very, very passionate about accountability and transparency in public schools. And if you're here today, I know that that is likely an interest that you have as well, either as a community member or as a public servant yourself. We achieve this goal by strategic, informed, and zealous advocacy for our clients in PR, news media, testifying at the State House, and in litigation. So who better for Kelly to have come talk to you about defending your district than a firm that works in part with suing school districts. I do have a disclaimer. What this presentation is providing is not legal help. It doesn't establish an attorney-client relationship, and this presentation is not legal advice. What I do want is for school board members to walk away knowing that there is valid and active litigation strategy supporting you in making the best decisions for your school districts. I'm not here to sue school districts that have a majority of school board members who are acting in the best interest of their students and their electorate. I'm not here to sue school districts that are fighting for true fairness and true equality within your district. I want to hold school boards accountable that are failing their districts, and despite these failures, continue asking for levy after levy with promises that things are going to get better. And if that accountability means litigation, then so be it. So for the community members that have joined us today, you guys are truly the watchmen on the wall that we communicate and coordinate with on a daily basis. You're our vigilant boots on the ground, and I want you to be informed about what kind of potential plaintiffs that you need to be looking for to be seeking legal help and pursuing their legal rights. We know that Ohio is densely populated by municipalities and local districts and public school districts, and your board members really cannot do this without your watch, and attorneys cannot adequately and accurately provide that help without these community members that are watching. So today we're going to discuss some various rulings in Title IX and in discrimination litigation so that you can be informed leaders within your districts and your communities. Much of what our firm offers is tailored to specific situations that clients have. And so this is going to be an overview of landmark legal principles and cases to keep in mind. I think that all of us being here today are pretty informed on big P politics, more so than the average citizens, or else you wouldn't be here. But there wouldn't be enough time for me to fully go into everything that goes into the little p politics. It's the inner workings of your school districts and of the hierarchy that is set in place. there's layers to these, and I value efficiency, so if we happen to get done early, you can take a break before the next session for the day. I'll also provide my contact info to send you these slides if you would like. So moving forward into, these are some of my op-eds that I've written if you want to take a look at those later. It's kind of addressing the cultural position of these issues. I'm going to try really hard to stick to today the legal issues that go into this. So as I stated,
People were trying to get a picture of
oh, sorry about that. Yeah, right ahead.
Yeah, it is.
Wow.
As an overview, we're going to be discussing Title IX, we're going to be discussing Title VII, we're going to be discussing Title VI. We're going to be looking into how that factors into anti-racism efforts, and we're also going to be talking about bullying and harassment, as well as addressing that kind of inner workings that we were just talking about. When we look at Title IX, in its simplest terms, faculty and administration in federally funded public school education entities are not allowed to discriminate on the basis of sex. June 23rd of this year actually marked the 50th anniversary of Title X, and Title X has been historically utilized to provide equal opportunities to men and women in the educational setting. It has since been expanded to include prevention of other sex-based discrimination, such as sexual harassment, providing a private right of action to sue. It's strange to think that Ruth Bader Ginsburg actually once discussed a need for Title IX in order to create separate spaces for women to compete against their peers. We are now in a place in the legal context where having separate bathrooms and locker rooms on the basis of sex hasn't really been successful in the courts, and not even in districts where we've seen a sexual assault take place because of those gender-based policies. And we're hopeful that girls' sports will continue to be an area in the legal field where we can make some necessary gains in litigation and legislation. Time will tell, and college scholarships and high school athletic careers are kind of hanging in the balance while we're waiting on that. If we look to some of these less sexy but still incredibly important issues related to Title IX, Title IX also means that there has to be policies and procedures in place that comply with state and federal regulations for reporting and investigating Title IX grievances against teachers, students, and administrators. This includes student-to-student occurrences, student-to-teacher occurrences, and this is really where we have run into issues in our law firm of administrations covering up sexual harassment between students, sexual assault from administrators or faculty involved in misconduct, and even corruption playing a role. We have administrators who and faculty who may have close ties to parents in the community, and really we find them treating the students in accordance with those ties. You may also see in this area some nepotism involved in those kind of cover-up situations, because a lot of family members often work within the same district. Friends and neighbors, that happens when you're dealing with close-knit district communities. This is really where you as a board member have to be making sure that policies are in place to provide that oversight and that accountability. And I know that lots of new board members come in with the goal of fiscal responsibility. And we're definitely supportive of that as taxpayers in Forest Hill School District. But hiring a contracted neutral third party to conduct Title IX investigations is going to end up being a lot less costly than a lawsuit that's related to these issues. When we look at having employees that are doing the work of Title IX investigations, we run into some issues that maybe their improper conduct or their relationships actually end up getting in the way of an unbiased investigation. If we see that there is repeatedly reported incidents of sexual harassment, assault, or discrimination with no action taken by the district, for the courts that may elevate that situation to a deliberate indifference, where the school district is being deliberately unresponsive to this kind of situation. We may also see things elevated in the courts to the level of shocking the conscience. Some situations we've seen with that is where we have incidents of school districts lying to parents, mischaracterizing evidence, or destroying or concealing evidence. We move on to Title VII. Really, this is overall the right to request a religious accommodation in employment. And so we are seeing COVID-19 definitely made religious accommodations great again. We had a lot of clients that were dealing with employers that really needed to request those religious accommodations to mandates in their place of employment. And we're also going to see within the context of this area, we get into more of the case law involving pronouns. And in your school, you may have some teachers that do not feel comfortable using the students' preferred pronouns because in the context of pronouns, we really see that that's leaning more towards an ideology more so than just a title. It's reflective of an underlying ideology that is often in contradiction to an employee's religious beliefs. Kind of a bit of case law to kind of open the door to this is that we see that this came up in the university context with Meriwether versus Shawnee State University. And I'm aware that this is not the K through 12 context, but where we pull from here some really interesting bits is that this is also a state actor. Anytime that you have an employee that is employed by a government-funded institution, they are what's called a state actor. And in general, we find that state actors have less free speech rights than those that are, they have more free speech rights than those that are in a private context, less free speech rights than students. So in this case, there was a professor that refused to refer to a male student with feminine titles and pronouns once he transitioned. And from there, the case was initially dismissed in federal court. It was then appealed in the Sixth Circuit, and the court ruled in favor of Professor Meriwether, holding that the university can't compel speech in opposition to free speech protections. So at this point, the university concluded with a favorable settlement of $400,000 in damages and attorney's fees, along with rescinding the original disciplinary measures that the warning that they had issued against Professor Meriwether. And again, it's that kind of unique situation that we have where the pronouns are indicative of an ideology and the university can't compel speech that contradicts the employee's beliefs or offends their conscience. So in the context of your schools, what that means is that you may have some teachers that feel uncomfortable using the student's new preferred name after they transition. And so they may also feel uncomfortable using the pronouns. If you have a teacher that's comfortable using the new preferred name, then that's a little bit of an easier situation for us as attorneys. We have a lot of names that depart from the traditional usage without the parents or the individual really denying a biological reality. There's men and women that are named Tyler, Sean, Ashton, Pat, Ashley, Chris, Sam. So we have clients that don't really mind respecting someone's wishes to be called by a different name. The other situation that we have is where the teacher may prefer to avoid first names altogether, and use names that do not use last names and they don't want to use a prefix, so they don't want to use Mr. or Mrs. or any of the pronouns. Either way, those are acceptable accommodations that are definitely defensible, and the employee would just be requesting that on their religious basis. And with a request for accommodations, unless that accommodation presents an undue burden to the employer, it would be unlawful to deny those. Whichever direction that the employee takes in finding a reasonable accommodation, what we want to make sure of is that you can protect your district from litigation by having that teacher treat everyone that's in that class the same way. So if you have a student that's transitioning and the teacher receives a religious accommodation to use a last name or to not use pronouns or just use first names, then they would apply that to all the students so that no student feels like they're individually called out or, singled out. Secondly, as we're still looking at the religious context, teachers and administrators who support anti-racist or gender-based ideology really shouldn't be able to compel speech and requiring a teacher or faculty member or a staff member to agree to some kind of training that's in place that involves that kind of ideology. If there is a training in place that involves that ideology that you haven't yet been able to root out as a school board member, really the leadership in the school is only able to test comprehension. And that goes for students and it goes for teachers going through any kind of training that involves that. They can ask for their comprehension on what they've learned, but they can't ask them to agree to that. And lastly, we'll just take a look at Kennedy versus Bremerton School District. This is fresh out of the Supreme Court. Many of you may have heard of it. The Supreme Court held that a school, this was a school out of Washington, held that a school cannot punish a teacher for their silent private prayer on public school grounds. So here the coach never required students to join him, but the school wanted his prayer relegated to a hidden either a custodian's closet or a press box or a building that was out of sight. And the Supreme Court ruled that this was unconstitutional. Working our way down the numbers from 9 to 7, we're going to Title VI. We're talking about how any public education entity that accepts federal funding cannot discriminate on the basis of race. So applying Title VI to modern day issues and legal concepts include cases that are currently brewing in Virginia courts. Specifically, we're looking at Albemarle County, where they have so-called anti-racist programming for students and teacher development training programs. These programs are in the courts right now, but they really run the risk of creating a racially hostile environment for teachers who are opposed to so-called anti-racist ideology and refuse to affirm its associated worldview. For students, these programs, really looking at more of the social schema of students and the context of kind of putting yourself in their place at their age and kind of stepping outside of what we look at as adults. They really add fuel to the fodder of the social pressure cooker that exists in student social interactions, especially when we start getting into the middle school and the high school years. The proponents of this kind of training tend to argue that it's preventing harmful social interactions between students, but in actuality, what we're seeing a lot is the opposite among our clients and among the communities. It's really been, I know that you guys have been probably talked to death about what all is wrong with critical theory from a cultural perspective, and I've shared the op-eds on that and about, I've written about the various ways that white, suburban, so-called anti-racists have attempted to stalk, harass, and silence me, clearly unsuccessful here today. But I want to talk to you about the legal liabilities of allowing that ideology to proliferate your school district. So, it's important to keep in mind that educator and student free speech rights are not equal. I touched on a little bit earlier that students have long held rights to free speech and expression with really few limitations. And on the other hand, public school teachers and administrators functioning as agents of the state, their free speech rights are often limited by the academic goals and policies of elected school board members. So when we look at the major forces that are working to oppose anti-racist ideology and equity and critical race theory, we don't really see with our clients so much that there's opposition to teaching American history. The opposition is against curriculum that presents skewed perspectives, that twists historical facts, that argues the opinion that America is fundamentally racist in the classroom. And this can open the door to situations, kind of related to Meriwether versus Shawnee University, where you have compelled speech and where you have a hostile environment that's created. And that would be opposed by Title VI or state level employment law. So the legal issue with divisive concepts is not necessarily that they're present in the classroom, but rather the buy-in or the promotion that is then required by the curriculum and the faculty. We know from Tinker, which is a landmark case, that teachers and students do not leave their rights to free speech at the schoolhouse gate. If a teacher is compelled to support a political ideology or a student is incentivized for selective activism, this opens the door to that First Amendment litigation surrounding compelled speech, restrained speech, and viewpoint-based discrimination. If we kind of put this in the context of an example, there's nothing really unlawful about a teacher discussing religion in class or current events as is related to the approved curriculum. The real legal issue comes in when we get into what can be described as proselytizing, where the religion or the theory is not just taught as existing out in the world, but it's not mentioned with a disclaimer of not being the personal views of the teacher, but it's really presented as being better or right or the necessary solution to the problem that's being addressed in the classroom discussion. For an example, an administrator can say that he or she has been reading books by Ibram X. Kendi in their free time as a way to grapple with current events. Not how I would grapple with current events, but to each their own. But that administrator should not promote critical theory as the correct or best method for confronting racism, since this social theory is just that. It's theoretical. And so proselytizing means going beyond that acknowledgement, tolerance, or existence of ideologies, belief systems, religions, lifestyles, etc., to actually promoting, endorsing, encouraging. Another way to look at it is really taking advantage of a captive audience. You have students that are beholden to someone who's giving them a grade. And when you look at the possibility that they're concerned about how their grade will be affected in that class by voicing their beliefs or by not agreeing to some affirmation of their privilege and their whiteness in class, that's really where we see teachers, faculty, administrators using that position of authority to create so-called disciples. So to kind of address the bullying and harassment aspect of litigation, we are going to take a small detour into a cultural aspect of critical theory, and that's interracial and intraracial Gnosticism. That's a mouthful. So there's, to kind of just give an idea, there's really not anything, I don't think, like more frustrating to an individual than to be told that, like, you don't really know why you think or feel this specific way, but I know why you feel and think that specific way. I know you better than you know you, so, I know best. And so it's really this idea that these members of a group have knowledge about another group that group doesn't have about itself. And so you get this circular reasoning in the context of race. Sounds a little bit like you're racist, but you don't know it. And if you don't accept it, it's because you're defensive and racist. And that would be the interracial Gnosticism, where we see it within a race as if it is like, aw, you think that you're not oppressed. It's because you're oppressed. That's why you think that. See, if you can imagine, like, pairing this concept within the pressure cooker of high school relationships, when all students want is to fit in, but they're being made to feel like they don't fit in because they have a different worldview or because they have an understanding of themselves that someone's not willing to accept, we really get to a point where we need to have administrators and faculty members and school board members that listen when students tell them how they think and feel, listen to parents as individuals and students as individuals, and work towards that mutual respect throughout your community. Racism is definitely real, and I haven't run into anyone who is in this opposition to critical theory who doesn't accept that racism exists. But the issue is that we see anti-racist efforts are part of the problem, not the solution. And when it comes to fixing racism, sexism, or any other ism, critical theory is critically flawed and critically racist. Racial sensitivity training, cultural competency training it all tends to separate out individuals into these buckets of oppressed and oppressors, and then it promotes pity on the oppressed and shame on the oppressors. And pity and shame is not only a destructive place to teach out of, but it is also a very suable place to operate out of.
That's good news, right?
Not for districts, but we really wish that we didn't have to do this work. We don't want to be doing this work, but you know, it's like we feel called to it. And when it doesn't exist anymore, we have plenty of other things that we can focus on before the minute we feel called to help individuals with messaging and with litigation that's related to this, because we looked around and it just was like no one else was doing it. No one else felt like taking on the attacks or speaking out about it. So, unfortunate, but we love what we do and we're passionate about it and happy to help. Lastly, just to kind of address, you know, what the next steps are for you guys within your community. Many times we're seeing that our clients who run for school board or public office or any other kind of leadership, they're not career politicians. They're parents who looked around at their community and they wanted to make a change. But the school's infrastructure within a district has often been in place for years. They are coming into this district, maybe they newly moved in, or maybe they've only seen it from the perspective of having a student that's moving through the school system. But their legal counsel for the district has seen boards and personnel come and go. The legal counsel and the superintendent may be best friends with the individual who just lost their race to you. So in many cases, you have to think of your administration in kind of this like deep state institution. And I'm not saying that there's not great open-minded legal counsel and administrators out there. I just haven't met them yet in the state of Ohio. It's the company, you can think of them as like the company man or the company woman. Their role is there not to steer the ship necessarily towards something better, but they just want to make sure that the ship keeps moving. And that's a very different goal than what our clients and the individuals that we work with have for their district. So I guess what the lesson is from seeing all that is advising individuals not to assume that your school district's counsel is on your side. They will be largely advised and influenced by your insurance company, and your insurance company will often encourage settlements where it should really be a fight. We have seen in school districts, particularly here lately, where we have individuals who are opportunistic, who would love to sue for minor infractions of open records laws, and they want it to just keep happening. If your insurance company encourages you to settle without understanding how this affects the vicious cycle that creates, you know, you're going to have that perpetuated, and you're going to be attacked again and again and again. So if you're often going to find that those that are in the administrative or the legal counsel position are going to support your fellow board members in disassociating from you or settling, or you might also see that if you have contracted communication firms or contractors that work with you. I think that if you kind of go back to the boat analogy, it's almost like the leftist kind of radical position is, you know, happy to crash the ship and destroy the ship, destroy the structure if necessary, and then your establishment, in-house counsel, and administrators are happy to just keep the ship running, a status quo kind of measure. And what I'm seeing out of our liberty-minded leadership and clients is that they want to steer the ship somewhere better. And I hope that this presentation helps you in your fight to help steer the ship somewhere better, because as an elected official, it's important to remember that it's not you and your faculty and your administrators versus those parents and your students. It is always you and the students and their parents. And then anyone who's on board with that can have a free ticket to ride. So thank you so much.